Welcome to panel A1A on international experiences of refugee status determination. I'm your chair, John Campbell from the School of Oriental and African Studies in London. And it's my pleasure to introduce each of these papers separately and each of the speakers separately. We will have all three presentations. So I'll begin now by introducing the first speaker. I'm really pleased to introduce Anne Margaret Wagana from Uganda. And Margaret is a magistrate of some years of experience working in Uganda. She has sat on litigation on cases for refugees, as well as, I'm sure, various criminal cases in Uganda over the years. And she's inspected refugee camps in Uganda. She is going to be looking at the issues of legal literacy in Uganda and comparatively in the North. And she wants to raise particular questions about how refugees understand their rights and how this affects their confidence and their ability to represent themselves fairly in asylum proceedings. So without further ado, Anne.
Yes, good afternoon. The time in Uganda is 12:32, so we're in the afternoon. The title of my presentation is Legal Literacy and the Refugee Asylum Experience, developed vis-a-vis developing countries. And since I'm Ugandan and by profession I'm a magistrate, as was said earlier, I'll be generally looking at the global north and specifically looking at Uganda. So on the next slide, we have the map of Uganda, which shows the different refugee areas, different places. I've visited most of the ones in the east and the west, and currently, before lockdown, I'm also doing work planting trees there. So now, on the next slide, I'm talking about the different statistics and nationalities of refugees in Uganda. We have from Burundian to Somali to South Sudanese. The majority of refugees we have are South Sudanese. So we have those that are in the refugee settlements, and then we have those that are freely moving in Uganda outside the settlements that have somehow integrated into Uganda. Approximately 300,000 are in the settlements, and the remainder of the 1.4 million are still moving around Uganda. So I won't go into the statistics. They can be found on the UNHCR page. So now the preliminaries on the next slide, the preliminaries show of what I'm going to be talking about. The process of asylum seeking varies between developed, that's the global north, and the developing world, which is the global south. So due to the status internationally, despite refugees being protected by international legislation and national legislation, and also kind-hearted individuals, we still see them as a vulnerable minority group. So through the lens of a magistrate, I have observed refugee litigants in my court. And I just want to look at the contrasting experiences between asylum seekers in the global north and those in rural Uganda. Majority of stations I've worked in rural Uganda are near the borders. So that is how I've been able to interact with them. Further, when we look at the deficient informational environments, I thought it would be important to look at legal literacy here. I'll further expound on what that is in other slides. And further, we need to also understand that politics plays a role in what is the high refugee influx into Uganda, if you look at the geopolitics of the East African region. And you need to also take into consideration that the differences between the North and South, while the global North, asylum appeals cases are mainly handled by the courts. In Uganda, you find that they're handled by the Office of the Prime Minister. The asylum seeking and registering of refugees is handled by the Office of the Prime Minister. which works together in conjunction with the United Nations High Commissioner for Refugees. And but courts come in the sense that statute, that's the the Refugee Act 2006 provides for appeal processes all the way up till the formal courts, but we do not have specialized asylum courts or tribunals dealing with appeals. Such appeals would go to regular courts, but since that hasn't yet been done, it's normally handled by, everything is handled by the Office of the Prime Minister. So legal literacy remains an important issue in assisting refugees in realizing their rights. So as we move to the next slide, the keywords, the next slide will show that the keywords I'll be looking at are legal literacy, asylum seekers, and refugee mobility. So legal literacy deals with people using the legal system and being able to guide themselves through the process so that they understand what's happening at different places along the way. So we can say that although refugees are told about their rights, they don't have that confidence to maneuver themselves through the legal systems to realize such rights. And from an ethnographic perspective, my experience in dealing with refugees, this is something I've personally witnessed. Also, the fear, the trauma that they go through in being in the courts. An ordinary person is fearful of a court setting. So you can already imagine what a refugee is dealing with, whether it's they're about to be deported, whether they're caught in a criminal matter, a civil matter, but they're normally at the receiving ends. But you can see that they do not have a full comprehension and confidence as maybe an ordinary citizen would have in going through the court process. Now, asylum seekers, my second keyword, an asylum seeker is one who requests for sanctuary and has yet to be processed. That's as per the UNHCR. And then finally, refugee mobility, refugees moving independently from their host country to the third country. That's from the Forced Migration Review. So now on the next slide, I show the European process. This is by the Asylum Information Database. I don't need to fully go through it. The diagram speaks for itself, but if you move a bit lower, you can see the bottom right, the appeals, the first tribunal that the asylum seekers go through when appealing matters. Then there's an upper tribunal all the way to a Supreme Court. There's also an option of judicial review. So statutory, Uganda does provide for something similar, but in practice, everything is handled usually at the Office of the Prime Minister. So on the next slide, we look at asylum determination in Europe. Anthony Good and Nick Gill have done a lot of work around that. They've done research in 10 different countries. They've looked at asylum determination in Europe and what happens in the courts, the legal system, the bureaucratic processes. And you can search for their book, very, very detailed. You can find that, you can purchase that online or the likes, but they go deep into the challenges of asylum determination. They also discuss like the states, the actors, protection of sovereignty, and asylum being in crisis. Now, Dr. Jules also researched into British asylum procedures and helped secure a High Court judgment that the detained fast-tracked appeals process was unfair and unlawful. The judgment was later upheld by the Court of Appeal, leading the government to suspend the entire DTF system in July 2015. So you can see research has been done on different European states, thorough research, which has been able to allow change. But on the other hand, in Uganda, yes, a lot of research is done around refugees in Uganda, but then we still keep refugees around the office of the Prime Minister. There's not much litigation regarding protection of their rights. And when you do that, that results in them fearing being registered, whether be helped and put in settlements. I visited some of the settlements, which are actually well kept. So you find them struggling and trying to integrate with the populations. And this normally brings tension with refugees. Nicole, can you move 2 slides down? Yeah, so there are statistics by the EPS from February 2019 to February 21, which talks about different applications lodged in the European Union. The COVID now is a big issue, which is affecting refugee movement. Minors are definitely affected, and there are different nationalities in the EU. So I won't get into that too deeply. That can be done further research on. So also there's different case laws. As for the next slide, you'll see like the different case law, which talks about different nationalities of people applying for asylum and different results. I just decided to mention that, not get into much detail about that, because that can easily be researched. Now, moving on from the global north now to the global south, Uganda. I'll quickly go through the legislation. The legislation governing refugees in Uganda, we have international law and then national statutes. So from international law, we have United Nations Convention, we have CEDAW, we have the Nairobi Code, the OAU Convention, we have several also Ugandan laws, the Refugee Act 2006, plus the regulations following that. And Uganda is heavy on policy. Yeah? We have the national policy for internally displaced persons. This policy allows refugees the right to, economic rights and the right of movement. So Uganda sort of tries to assist refugees more in integration. Yes, over the past 2 decades, literature has shown that the 3 solutions of integration, repatriation, and resettlement do have their challenges. There's vast peer-reviewed literature that really goes into that. But then even within those challenges, there are still some positive elements. And I think Uganda is really heavy, especially on integration, because resettlement is quite difficult. And we are trying not to be in a similar situation like Kenya, where refugees are kept in camps. There's encampment, and that breeds terrorist organizations, that breeds tension between the nationalities in there and the hosts. And you'll normally find during political situations, there's always threats to close down Dadaab and the likes. So Uganda sort of takes a different approach. It's not perfect, but it's something that's coming along. Now, when it comes to asylum procedure in Uganda, on the next slide, we have the Refugee Act 2006. So under Section 3, Section 3 talks about the application for refugee status, where a person who enters Uganda and wishes to remain in Uganda shall apply to the eligibility committee for the grant of refugee status within 30 days. Now, there's various sections dealing with the formalities of the application. Now, moving on to the appeals, which is more integral to the presentation, the appeals occur when the application for refugee status is denied. So an applicant aggrieved by the decision of the eligibility committee may appeal to the appeals board in writing within 30 days. Now, I've noticed that the Makerere has Makerere University. So that's the largest university in Uganda. Has a refugee research institute, which really does a lot of work with the refugees and the likes. But in as much as they contribute a lot to research and legal aid and etc. around assisting the refugees, one of the issues I insist on is that all this happens within the OPM case. OPM is the Office of the Prime Minister, which handles refugees. Now, you find that although the 2006 Act gives refugees rights to lawyers to represent them, to making appeals to appeal board, and also having the opportunity under Section 9 to apply to a court for judicial, like a court as in a formal court for judicial review, you find that this is not normally the case. Matters start in the Office of the Prime Minister and also normally end in the Office of the Prime Minister. So we don't have precedents on cases as in like the Global North and probably some of the other Global South countries. We don't have case law to support refugees should they choose to go to court, because normally
Annie,
they can't even.
You have 5 minutes, Annie.
Yeah, okay, it's okay. Normally they can't afford even getting a lawyer, plus we see that the matter doesn't go beyond that. So on the next slide, we can see that this goes to the imperfect environment whereby they have legal challenges. They don't normally have a good grasp of what's happening with them, and they don't also have abilities to apply for higher instances. So now, like to formal courts. So on the next, the judicial officer in Nakawa court, there's normally an open day where refugees give their grievances, and they touch on issues of trauma, fear, language barrier. You can see from the different nationalities that I mentioned, lack of interpreters in court, which is something I've experienced, and lack of mobility in the courts, like from the settlement to the courts. So in conclusion, some of the recommendations that I was considering are decentralizing autonomy of the Office of the Prime Minister, like involving more lawyers, pro bono lawyers, that is in the eligibility committee application process to increase acceptance, and involving lawyers in appeals processes to force the board, which normally doesn't sit, but to force the board to sit and review decisions, which is rarely done, involving lawyers in appeals to formal courts to create jurisprudence around asylum cases and give refugees more of a chance of staying and being registered, adopting best practices from countries like the UK and other countries which have shown results, allowing deported and documented refugees caught up in informal courts a chance to appear before the eligibility committee, considering intensifying legal literacy through sensitization processes, and finally, continuing with legal literacy on open days to sensitize the court users, especially on handling refugees. Thank you.
Thank you very much, Annie, for keeping to time, even with 1 or 2 minutes to spare. Okay, we move on to the second presentation, which is by Cristiano Dorsi. All right.
Okay, thank you so much, Professor Campbell. Yes, my presentation is on policy and practice of the encampment in Southern Africa, and I'm starting from the title because the title is South Africa has no camps. So the attitude of judges in refugee claims adjudication concerning the policy of encampment in other African states. In fact, we will come back to South Africa just at the end because there's still a debate of the encampment or not of South Africa. But when we focus on refugee claims adjudication in Southern Africa, the first and perhaps only country that comes to mind to an extra African expert is South Africa, whose courts have historically been sensitive to refugee claims. However, as South Africa formally has no camps, South Africa judges have never adjudicated expressly on this delicate subject. Conversely, this matter has been adjudicated in other South African countries that promote and implement encampment for asylum seekers and/or refugees. So my presentation focuses on assessing the adjudication by the courts, as well as state policy of other African countries concerning the encampment of refugees. It will be mostly Southern African countries, but I will also mention another couple of African countries, in fact. Indeed, in the past, courts often tended to endorse the encampment policy put in place by governments, such as, for example, in the famous 2008 case Ex parte Nzambimana that was decided in Malawi, in fact. In that context, the High Court of Lilongwe declared that the request of the applicant to quash the order of the respondent, it was the Department of Poverty and Disaster Management Affairs, giving notice to all refugees and asylum seekers residing outside designated areas to return to the appropriate camp, had no merit. It was basically was Zaleka camp. Historically, however, Malawi, whenever the activities of refugees served the economic interests of the state, adopted a more tolerant policy towards them. In converse, when refugees' activities challenged these interests, national governments implemented a more aggressive and interventionist policy. For example, the influx of Mozambican refugees is believed to have forced Malawi to rush the process of ratifying the relevant international refugee instruments, as well as drafting the Refugee Act, which came into force in 1989, but now is clearly outdated and it does not include any provision related to the encampment of asylum seekers and refugees. The view of the Malawian court has been completely reversed in 2017. It means 9 years after, in a Kenyan case, the so-called Kituo cha Sheria Kenyan case. In that circumstance, the Kenyan government had issued a directive requiring relocation of refugees living in urban areas to refugee camps. However, the respondents saw that the court declared the government's decision unlawful. In that case, the High Court of Nairobi quashed the government directive. Along these lines, in fact, not by chance, the 2006 Kenyan Refugee Act is one of the very few refugee laws in Africa acknowledging the existence of camps, dedicating its entire section 17 to the eminent figure of the refugee camp officer. The law, it doesn't speak clearly about camps, but speaks about the refugee camp officer, in fact. And another piece of legislation that mentions camps in Africa, that it's the first one to have expressly mentioned camps, in fact, is the 2008 Gambian Refugee Act, in its section 42. And in fact, it's called Designation of Refugee Camps. So it's the first piece of legislation in Africa to expressly mention refugee camps. I mean, it's the Gambian Refugee Act. In fact, section 42 affirms that, I'm quoting, in cases where refugees arrive in large numbers, the Secretary of State may, by an order published in the Gazette, designate refugee camps to house the refugees. Unfortunately, until now, Gambia authorities, they never adjudicated any case about, in fact, refugee camps in the country. But in the early 2000s, there were 5 refugee camps in the Gambia. The prima facie refugee status for Liberians and Sierra Leone's ended with the tripartite cessation agreement between UNHCR, the Gambia, and the country of origins, and along with it, the entitlement to protection and assistance. This made the camps obsolete in the country, and by 2005, all camps were closed. Even prior to this, many refugees voluntarily repatriated or chose to live in urban areas instead of camps. However, the newly arriving refugees from Casamance in 2006, Casamance is the southern part of Senegal, were not placed in refugee camps. For the Casamance, settlement in the southern areas makes sense in light of ethnic and cultural homogeneity in the region. The ensuing self-settlement was therefore partly a result of the behavior of the refugees themselves, but is also considered to be the best option for both refugee and host populations. Most Casamance refugees live in a cluster of 86 border villages up to today. The food and material assistance has been downscaled since 2010. Other opportunities, such as skill training, are still available to the Gambian Food and Nutrition Association, an NGO which provides much of the support to the refugee population in the Gambia. An interesting case in Southern Africa about encampment is undoubtedly the case of Botswana. That Botswana restrictive encamp policy continued in recent years, denying refugees freedom of movement, work, and local integration. Asylum seekers face lengthy refugee status determination procedures, and asylum seekers with both pending and denied application continue to be detained, often in the Francistown Center for Illegal Immigrants. The duration of the detention averaged between 6 months and 5 years. This is far beyond the detention period that is stipulated in the 1968 Refugee Act. The Botswana Refugee Act is one of the oldest in entire Africa. And in that act, it says that an illegal migrant can be detained for no more than 28 days. On April 2017, the High Court in Francistown ordered the release of 2 Somali asylum seekers from the Francistown Center for Illegal Immigrants. They had been detained in the center since being denied status in refugee status in October 2015, having arrived separately in Botswana in June 2014. On April 15, following their release, they were taken into custody at the Twokeng police station after attempting to enter the Dukwe refugee camp. There is the only Botswana refugee camp, in fact. On April 25, 2017, President Kama declared them to be prohibited immigrants. They were subsequently detained at the first offenders prison in Gaborone and have allegedly since been deported. However, in November 2017, the Court of Appeal in Gaborone set aside the High Court ruling that the detention of 165 asylum seekers and their relatives was illegal. In 2018, the High Court, responding to an application by the group of this 165 person in the Dukwe camp, ordered that the man generally acknowledged as the leader of the refugees, Mr. Felix Kakula, should be released from the center for illegal immigrants where he was being held and returned to the camp. The High Court also interdicted anyone from deporting the camp people to Namibia or to Caprivi Strip, pending a review application. Further efforts at repatriation were also interdicted until the reason for fleeing no longer exists. The Botswana Minister of Immigration and Gender Affairs at that time appealed this interdict, and the latest judgment is in response to that appeal. The 3 judges from the Court of Appeal noted that the people from Caprivi in the Dukwe camp were no longer recognized as refugees, and thus had no right to be treated as refugees or to be held in a refugee camp. The judges ruled that for various reasons, 2 previous court decisions in favor of the refugees were wrongly made, and that the latest interdict should be overturned. This is called the Muyela case. The Court of Appeal also noted that while the Botswana government was keen to get moving on the repatriation of the Caprivi Strip via the go and see, come and tell approach, the refugees themselves did not want to engage on repatriation. Botswana, in fact, enter a reservation to the Geneva Convention, 1951 Geneva Convention, on both the freedom of movement of refugees and their right to work. In practice, asylum seekers are detained at the Center for Illegal Immigrants pending the determination of their status. Asylum seekers and illegal immigrants, in fact, share the same facility. The lack of a separate facility for asylum seekers, in fact, is not desirable. Some asylum seekers, traumatized by the experience of flight, need specialized facilities such as counseling and psychological support. Such facilities are not available in the detention center, of course. That's why it has been argued that asylum seekers should be accommodated separately from illegal immigrants, and that a special regard be given to their unique position. In the event the refugee status is granted, refugees are removed from the Center for Illegal Immigrants to the Duqui refugee camps. This camp, in fact, is a rural and remote setting, and the economic activity of refugees is therefore severely curtailed, in fact. In another case, a previous case discussed by the High Court in Botswana, the Sefo case in 2005, what also in paragraph 19, what the court said, I'm quoting, the petitioner are failed asylum seekers. As such, they ordinarily must be detained at the place designated for that purpose until they are removed from the country. Since the rejection of their application for recognition as asylum seekers, they have permitted to reside to Duqui refugee camp and only move to the Center for Illegal Immigrants when the authorities decided, because of events at the refugee camp, that they should now deal with them strictly in accordance with their status in the country. I therefore, this is the judge talking, come to the conclusion that the petitioner are detained at the Center for Illegal Immigrants not because they are suspected of having committed an offense or of involvement in disturbances at the refugee camps, but principally because they are failed asylum seekers, who according to the Attorney General should be removed from the country. The petitioner arrest and detention do not therefore arise from the suspicion that they commit an offense. Also in this case, there was a previous case, the judges said that the authorities, the Botswana authorities, in fact, they were right in detaining asylum seekers in detention with failed asylum seekers, in fact, in detention with illegal migrants. Paragraph 31 of the same judgment, the petition of detention is lawful in terms of Section 14 of the Immigration Act. The attorney concede that presently their detention is lawful. There is no basis on which I may declare, is always the judge talking, that the petitioner detention at the Center for Illegal Immigrants is unlawful. I'm not reading the Section 14 because I don't know if I have time, but speaking another reality in Southern Africa, we have the case of Namibia as well. That refugees have been warehoused at the Ozire refugee camp because of the very fact that Namibia has noted a reservation to the Geneva Convention in respect of freedom of movement of refugees. According to the Namibian interpretation, refugees have to remain in the camp and may only leave the camp if they obtain a permit from the Ozire camp administrator. Consequently, they cannot scout for jobs or engage in social activities to improve their life in the country. This presents the problem of limitation of other important rights, especially the socio-economic rights of refugees. There is no existing literature on interpretation of the 1999 Refugee Act, except for the decision by the Namibian Refugees Committee. The Citizen Act 14 of 1990 that regulates the acquisition and loss of Namibian citizenship in accordance with Article 4 of the Constitution is also central to any debate on refugees. This is so because one of the solutions to the current dilemma of refugees also at the Ozire camp is local integration. Local integration requires that refugees who do not wish to return to their home country be integrated into the Namibian society and economy. This would entail the granting of Namibian citizenship. Consequently, it is imperative to consider the appropriate provision on this act in that context. In effect, the Ozire refugee camp was originally a detention center during South African apartheid rule, and Ozire was officially declared a reception area for refugees in 2000. The regulation under which it was declared were promulgated in accordance with Section 19 of the 1999 Refugee Act, which states, I'm quoting, notwithstanding the provision of Article 26 of the UN Convention, the Minister of Home Affairs may, by notice in the Gazette, declare any part of Namibia to be an area, in this act referred to as a reception area, for the reception of or residence of recognized refugees and protected persons, persons who have applied in terms of this act for refugee status, C, members of the families of persons referred to in paragraph B, or any categories thereof, as may be specified in the notice. The minister, paragraph 2, may by notice in the Gazette establish in any reception area a refugee settlement for refugees or any category of refugees. The minister may designate an authorized officer to be in charge of any reception area or refugee settlement. To conclude, I'm talking, as I mentioned at the beginning, I was mentioned briefly the issue of South Africa. In fact, South Africa doesn't have officially a refugee camp. The policy of encampment has been historically adjudicated in different ways according to the country of adjudication, as well as according to several conditions, such as the government in place or, on occasion, pushback from civil society as well. Meanwhile, in April 2021, I mean 2 months ago, the South African Minister of Home Affairs has rubbished the notion that people have been placed in refugee camps in the region. The South African Minister of Home Affairs reiterated that the term refugee camp should not be used loosely, and there is more meaning behind it. I'm quoting him, very deliberately, this country, South Africa, in its constitution, opted for a policy of non-encampment, meaning people who migrate to South Africa for one reason or the other should not be put in camps or be subjected to life in refugee camps and all its ramifications. He added, I think it's very important for people to understand this because time and time again, it gets distorted when we deal with this problem. We don't put anybody in any camp because they happen to not be South Africans. I think I need to repeat, it's extremely important to understand this because many people, even the media, have persisted in characterizing the shelters in Cape Town as refugee camps. He said this while there were many refugees and asylum seekers living all over the cities, on farm, rural areas and villages in South Africa. None of them have been subjected to any camp whatsoever. However, on several years before, I mean on 28 July 2017, South Africa adopted a white paper on international migration in South Africa. Regarding the paper's proposal to boost South Africa's migrant asylum detention capacities, the Scalabrini Center, that is an NGO being based in Cape Town, and he's dealing a lot with asylum seeker and refugee issues here in South Africa. What they declared in 2017, the Scalabrini Center. We fear, I'm quoting them, we fear that creating detention center in remote areas of the country will result in long-term detention of vulnerable people without adequate support or adequate conditions. Such detention is unconstitutional and contrary to international law. Aside from being expensive, research shows that encampment policy do not deter migration and could cause resentment from local South African citizens. They added, and I'm done, we have deep and grave concerns around the change to the asylum system in South Africa, which we believe will result in unconstitutional camps on the border, where thousands of asylum seekers will risk having their most fundamental human rights abused. More generally, the terms used in the white paper, such as illegal migrant rather than undocumented person, contributes to the unnecessary criminalization of migrants. Thank you so much, Professor Campbell.
And thank you, Cristiano, for keeping to time. The next presenter is Valentina Grillo. Valentina is a PhD candidate in anthropology at the University of Vienna, Austria. And she's been looking at asylum cases and asylum claims in Palermo, where she's particularly interested in the work on Bangladeshi migrants. Valentina, welcome, and please begin.
Thank you very much, Professor Campbell, and thank you everybody for being here. Good morning and good afternoon, everybody. My name is Valentina and I'm a PhD candidate at the University of Vienna, Department of Social and Cultural Anthropology. Today I will present a contribution that has been already submitted for publication under the title Bangla Stories, an introduction to the Bangladeshi community, their legal experience of asylum and the migration apparatus in southern Italy. So the material collected for this presentation has been elaborated upon thanks to my working period in southern Italy in the field of international protection over a period of 3 years. And this material has been integrated as well with expert interviews with stakeholders working in the field of international protection in southern Italy, and narrative interviews with Bangladeshi applicants. So all this together made this research project, which is ongoing, and it is different from my dissertation at the University of Vienna. So feedback, comments, questions are highly appreciated. And before going to the outline of the presentation, I would like to draw your attention to the first part of the title, namely Bangla Stories. The word Bangla refers to the South Asian country, namely Bangladesh, from where in 2017, 8,000 people migrated only to southern Italy and in particular to Sicily. The community migrants from Bangladesh refer to themselves as well with this shortened form, which is also used to refer to specific kind of grocery stores, very popular in the city of Palermo in Western Sicily. But we will look at that later on in the presentation. The term stories, instead, an account of past events in someone's life, refers to the so-called testimony that asylum seekers are asked to give once they arrive in Italy and apply for asylum. Secondly, it refers to the importance to bring in a human gaze, human perspective in the study of migration, as already 10 years ago, for example, Sandro Mezzadra emphasized. However, I argue here that it is worth analyzing asylum law and the so-called migration apparatus that, in Gregory Feldman's words, affects refugees' lives. So for this reason, we will firstly go to some of the features of the Bangladeshi community in Palermo, the biggest city in Sicily in southern Italy, to then move on to the refugee status determination procedure at the territorial commissions, namely the first institution that assess the applications in Italy. And by looking at the refugee status determination procedure with an eye on discursive practices, then it is possible to grasp refugees' perspectives. So for this, we will conclude with some of the most peculiar aspects of migration policies in Italy, to finally conclude with some remarks. So I will now start with the first point. The Bangladeshi community in Palermo is the biggest community of migrants in Palermo in terms of numbers. But in addition to quantitative aspects, the community is extremely relevant in cultural, political, economic, social terms. And now in this first point, I will show you this aspect through three main examples. So firstly, let me check if the audio is going on. I'm not sure though.
Yes, we can hear it's low though.
Okay. So culturally speaking, this video was, I took this video just before the pandemic in December 2019, when the community celebrated the Independence Day at this cultural center in Palermo, as well in the streets of the city. With concern to political aspects, this screenshot shows the political representatives directly elected by the migrants community in Palermo. I will not linger on the role of this group or in the political debate in Palermo, but right now this is very interesting to see how out of 21 representatives, 4 of them come from Bangladesh. Finally, this picture shows a Bangla or Bangla store, which is very popular in southern Italy, and in particular in Palermo, among the Bangladeshi community, but also the Muslim community, and many Asians customers buy there because they might find specific items they cannot find in Italian shops, but also Italians. And this is also because it is a 24 hours shops that for urgent shopping at nighttime is extremely useful. So overall, this first point helped me outline some of the features of the community coming from this specific country. And I would like to add still 2 main aspects, namely the fact that migration from Bangladesh to Sicily has sharply increased in the last 3 decades. And most of the people arriving right now have a very low education level, but still they have a very good employment rate, especially within the community, but not always. This is of course not the rule. And they're very united within the community of origin. You might ask yourself, what does it have to do with the refugee status determination procedure? Well, I will try to explain that in the second part. And in particular, all Bangladeshi, the majority of Bangladeshi people arriving in Sicily, they apply for international protection. However, there is an extremely high rate of rejection at the very first level of judgment, meaning that in 2019, for example, 93% of applications were rejected at the first instance. And once the applicant applies for asylum, he or she might be granted, recognize the refugee status, the subsidiary protection, or a special protection, which is peculiar to the Italian legal system. All these forms of protection are have been implemented differently in the Italian legal system. However, all of them are based on Article 10 of the Italian Constitution that recognizes the right of asylum. So I will continue this first point by outlining briefly the steps of the refugee status determination procedure in the territorial commissions that are that corresponds to the Home Office, for example, in the UK, then we will move on to a specific claim made by a Bangladeshi applicant. So once the applicant applies for asylum at the police post or at border posts, these forward the application to the Territorial Commission, which again is comparable to the Home Office in the UK, and it is part of the Ministry of Interior. Their case officer conducts an interview with the applicant, and at the same time, the officer types down the content of the interview. At the end of that, he or she will conduct an analysis of the relevant facts relevant for the asylum application, as well as the so-called credibility assessment that, in combination with the country of origin information research, will lead to a decision that needs to be firstly discussed in the Territorial Commission, namely with other members of the Commission and the President of the Commission. So the relevance of the Bangladeshi community is also quite evident from this picture I took in front of the Territorial Commission of Palermo, where information is provided about office hours is provided in two languages, namely Italian and Bangladeshi. Despite the formal relevance of the Bangladeshi community at the Territorial Commission, unfortunately, the claims of many applicants are dealt with roughly and in very limited time frames. You might ask yourself why. We will look at this in a very concrete case, namely a case that has been submitted from a Bangladeshi applicant who claimed that he belonged to the opposition party, and during election times he was subjected to violence and episodes of harassment. So for this reason, he left his country. However, although these informations were confirmed by the country of origin information research, the application was denied. And the formal reason for that was a credibility issue, namely the fact that the applicant did not have enough knowledge about the political principles, ideals, and agenda overall of the party. I will comment this decision through the words of an expert interview, and this is a caseworker who used to work in the field of international protection, who on this exact claim said it is more or less normal that belonging to that party is motivated by other reasons that are not necessarily political ideals. In that case, it makes sense to look for a personal participation and motivation, and said the refugee status determination procedure cannot expect that the interviewee knows each political detail. I would add on that, especially if he has a very low education level. Anyway, the political claims of Bangladeshis is usually rejected. So this first point was very important to highlight the attitude that I was able to observe in Western Sicily among case officers who might be most of the time passionate of their work, but being dependent on the Ministry of Interior were obliged to work in a very limited time frame, and therefore there was a sort of attitude of disbelief, skepticism, and mistrust towards applicants coming from certain nationalities. And this is the case, was confirmed often for Bangladeshi claims and Bangladeshi's applicants. And moreover, such an attitude led to the not taking into enough consideration certain aspects of the claim. And one amongst all is the journey of many Bangladeshi people who are able to leave Bangladesh thanks to a mediator who lent them money or straightforward bite, organize for them the journey with a fake visa, with ticket flight to Libya, from where they're able then to cross the Mediterranean Sea. And once in Sicily, they're able to find a job within their community. But in the very first phase of their work, they barely see any money because they have to pay out the very high interest rate of that debt. And this is a scenario that might lead, according to Italian law, to the recognition of a specific permit of stay, which is granted to victims of trafficking. That is, for example, often recognized to Ivorian or Nigerian women who were able to arrive to Italy through the prostitution network and trafficking networks. However, this is most of the time not the case. And to better understand that, I would like at this point to link all these with some discursive practices, and in particular some aspects that are very relevant with regard to migration policies in Italy. And
Valentina, you have just under 5 minutes, please.
All right, thank you. With this regard, I will show you this map, which lacks a lot of knowledge, but however will help me trace the most important aspects in Italian policies. And I would like to start with the hotspot approach, which introduced in 2015 in Italy, led to a very specific migration management approach, which divides incoming migrants between economic migrants and asylum seekers. This has gradually led, this is what I argue, to support such an attitude of distrust to certain nationalities and to certain applicants coming from certain countries, which is as well aggravated by certain notions that are promoted in very recent laws, immigration laws, that introduce notions like third safe countries or accelerated procedures only with regard to certain applicants coming from certain countries. So to show also the contradiction that this attitude, which is very common, that economic factors need to be sharply distinguished from the asylum application, I would like to briefly show you this decision of a judge. After this is a different case than the one we just saw before, that a Bangladeshi applicant, after the rejection of the Territorial Commission, appealed this decision, and the judge in his decision wrote, surely, I'm sorry that this is in Italian, however, you might find that online at Melting Pot. And he said, he wrote, surely these economic reasons led him to leave Bangladesh, but these reasons need to be evaluated together with the general situation of his country, the economic, political, and social situation. Such a decision led the judge to recognize not the refugee status, but the humanitarian protection, the so-called special protection. And I would like at this point to just highlight two final and temporary remarks. The first one relates to tribunals and the fact that tribunals appear to be much more independent spaces, institutional spaces where asylum law is applied, and there is massive work in Italy because since 2018, there is an ever-growing number of rejections from the territorial commissions all over Europe, all over Italy, sorry, and these have been appealed. So there is a lot of material to work on and to research on. This is kind of my hope and aim. And finally, one final remarks regards the Bangladeshi community. And I will also maybe link to what Margaret was saying with the aspect of legal literacy. The Bangladeshi community is very the Bangladeshi people are very bound to the community, and from the outside, they look very united, but most of the time, Some nations prevent many people to access basic and fundamental services that are offered, like the one of legal assistance, to all asylum seekers. And most of the time, such a very high rejection rate experienced by Bangladeshi nationals is also due for a lack of preparation for the testimony. That is fundamental, of course, for a successful accomplishment of RSD procedure. Thank you very much for your attention.
And thank you very much, Shantina, for keeping to time. We are at the end of our session, so I would like to thank all three speakers. I'm sure the audience would too.